All right, so this is our third time doing this over the course of 6 years, and it's my fourth. Is it your fourth too?
I think it's my third, but
I did it by myself the first time. And I think it was just because you guys wanted to gain intelligence on what the debtors do. So this is our last time doing this. I know you guys will be sad to see us go, but
I feel like this is sort of like American history class in high school. Every time we do this presentation, we say we're going to get all the way through it, and we never do. So maybe this year we will actually make it all the way through.
The presentation.
So that's our goal.
We'll try. We're going to race through it this time.
So essentially what we are here to talk about you all today, and what our presentation sort of focuses on, is to give you an overview of the collection process from start to finish from both sides of the table. So from both a debtor's perspective, and a creditor's perspective. And the presentation is essentially designed to point out to you various issues that you will likely encounter along the way, and to just sort of lay out your timelines for you and what you should be anticipating and expecting. So the first, let's see here. The first thing when you undertake any type of representation is you want to make sure, obviously, that you don't have a conflict of interest. I think that there are several, common conflicts of interest that arise in the collection setting, but obviously, before you go ahead and undertake any type of representation, you need to make sure that you're following the rules of professional conduct. So essentially, an attorney can't be, as you all know, directly adverse to a client or undertake a representation where there's a risk that the representation is going to be materially limited by the attorney's personal interests or responsibilities. So as soon as somebody walks in your door and says, hey, I need a lawyer, you want to be going ahead, getting their name, running the conflict check. Just sort of your basic, good practice pointer there. I think that on the creditor side, in terms of potential conflicts, generally speaking, if you represent a big, like a financial institution, one of the things that we typically do is we will ask for an advance waiver, which essentially has our potential client indicating that they recognize that, we may have clients currently or in the future who could possibly be adverse to them. Not directly adverse in the particular matter that we're working on, but that could be adverse. And sometimes we get pushback from potential clients on whether or not they want to give us the advance waiver. And I think these days I've kind of come to think of it as almost a two-way street of loyalty, if you will. If it's going to be a client that's going to generate a lot of business for me and my firm, I may be willing to just kind of, swallow and say, okay, I can forget the advance waiver. But if it's going to be a smaller client who's not going to send me a lot of business, and maybe this particular matter is only going to bring in a couple $1,000s, then I'm going to think really hard about whether or not I want to forego that advance waiver, because I don't want to be conflicted out of a whole bunch of other representations down the road just because I have this one particular matter that I couldn't get an advance waiver for. So just something to kind of consider as you're walking through the process. I think on the debtor side, we also tend to see lots of sort of recurring conflicts of interest, if you will. And I think lots of those stem from whether or not you're representing the borrower, if you're representing a guarantor, if all of the obligors want you to act as their counsel. So there's sort of a whole host of potential conflicts that can arise there.
Yeah, I mean, we have the normal, regular conflict of interest issues also. I mean, when I represent a lot of Chapter 11 debtors primarily, and when you represent them, they're going to have tons of small companies and vendors that they've done business with over the years. And when you're a member of an 8-person law firm, you're bound to have some conflicts. And so there are still issues that arise where, we find a creditor on the schedules that somebody in my firm did their partnership agreement or something like that. So we still have to deal with the traditional issues, but we certainly avoid them as best as possible because we just don't represent banks. So as long as we stay out of that world, we're usually okay. As far as representing the debtors, the biggest problem that I have is that the debtor, the principals of these business expect you to represent them as well. And more often than not, the interests of the business is not the same as the interest of the principals.
Although it may start out that way,
Well,
but things can quickly change.
Right, they do quickly change. So primarily when I meet with a troubled business, we first assess whether, are we shutting this down and just moving on with our lives? I mean, if the case is it's dead, it's never going to do anything again because its product is obsolete, its sales force has left, its major customers gone, whatever it is, then it's less of an issue to go ahead and represent the principals along with the business because effectively you're just really representing the principals. The business is going to turn over the assets, liquidate, do whatever it can, and then the guarantors are ultimately on the hook, which are the owners. So it's fine in those situations to represent the three because there's really no conflict between the two and the business is going away. The issues that I've had more recently, and actually had it yesterday on the phone, was in Chapter 11 debtor cases, a lot of times the principals are going to be the ones that fund the operations whenever there's a shortfall of cash. And what sometimes they struggle with understanding is that I require them to go get a lawyer to represent them on that lending because what is best for the business as far as that lending goes is not best for the guarantor because a guarantor doesn't, or the principal doesn't want to lend unless they're going to get a lien on some assets, they're going to get a first priority, they're going to get an administrative claim, something. As far as I'm concerned for the business, I don't want to give you any of that. I want you to just lend the money because it's your business and you think you can make a go of it. And so I did that in this situation months ago when the principal lent the money. And yesterday I had a buyer, an investor, call me that was interested in the business and said to me, how in the world did you let that principal lend money on that basis? In the sense that he was unsecured, he'll probably never be paid, he's last priority, but he had his own counsel, and that was my response. I said, well, I sent him, he went back to his regular lawyer that had done all his work before I came along, and he represented him in the transaction, and so that's who you need to talk to if you don't think the terms were fair. So it's a big issue when you're really dealing with businesses and principals, because the principals struggle with understanding why you cannot represent them when the bank sues them in state court, to foreclose on their guarantees or their homes that have been, used as collateral or what have you, because frankly, it's not in the best interest of the business to do that. So it's a real struggle. You have to pick your client, basically.
Yeah, and when we do debtor work, we tend to always put in our engagement letter, if we're only representing, for instance, the borrower, that we are only representing the borrower or the company. We are not representing any of the other, guarantors or principals. And if an issue arises, you likely need to go out and get separate counsel. We always like to put that language in there just to be crystal clear up front what our understanding of the engagement is so that there's no issue, further down the road. Right. And another thing that we often do when we're representing a debtor as well is, obviously, we have concerns sometimes about getting paid.
You represent debtors?
We do. So what we'll do is we'll put in our engagement letter that the representation does not begin until we actually receive the retainer. Because, lots of times you'll have companies who are struggling and they have no qualms about telling you the check's in the mail, even though they're looking for you to be their attorney, and sometimes it's not. So we like to put that.
I'm shocked. That's never happened to me.
So we like to go ahead and put that in there too, because that gives us an opportunity to say, look, this representation didn't start, we still haven't gotten the retainer. So just another sort of practice pointer there.
Sure. And if we're going to go into engagement agreements, though, that would be another practice pointer is when you're dealing like I do with troubled clients, get as much money up front, easier said than done. Ideally, though, when I'm pricing a Chapter 11 case, I'd like to get through pre-petition stuff that has to be done, and I'd like to get through the first 3 months. Doesn't usually happen. Usually I get through like pre-petition and maybe a month if I'm lucky on the retainer. But when they're troubled, it's hard for them to come up with the money, obviously. But that's a good point. You have to look. You also have to look down the road. Is this debtor going to be cash flowing to even fund me in the future? How long is the life of this case?
And I think another point too is you like them, I'm sure, to stay current on their bills so that you're not an unsecured creditor when they file. You don't want to be in a position of having to waive that.
Well, we have 2 engagement contracts, and that's the next topic is the engagement agreement. When I represent people before they file bankruptcy, I have an engagement agreement where I'm trying to do a workout. Maybe we're just resolving issues with certain creditors. We're hoping to stave off bankruptcy, so I'll have the one engagement letter that is for that. Then if it does transition into bankruptcy, if they owe me money at that point and haven't stayed current, then I will not be bankruptcy counsel for obvious reasons, not the least of which is that I could be sued for a preference later. So I do tend to try to keep current. Usually there's such a short window, it's not a big deal. It's usually, a small amount of money before you file the bankruptcy. But then I do a separate engagement agreement once we determine what type of bankruptcy they're going to do and that kind of stuff.
Yeah, and I think on the creditor side, in terms of, you hit on it a little bit here, but in terms of, fee arrangements, I mean, there's all sorts of, as you all know, different types of fee arrangements. I think when we actually first started doing this presentation, alternative fee arrangements were just coming out and were, the great, buzzword that everybody was talking about. But you still see, hourly rate, discounted hourly rate, contingency fee cases, all of those types of situations. And I guess really, at least for me, it kind of depends upon who my client is. Again, if I've got a big client who's going to be throwing me a lot of work, I don't necessarily request a retainer or, have concerns always about getting paid, and it may be that we do certain things on a fixed rate. It may be that certain things are done on a contingency basis. I do, though, if somebody's asking me to take a collection matter on a contingency basis, like to pre-screen it. I want to go out and do my due diligence to see if I think that it's a case that's actually going to generate money, because if I'm, looking at something that, looks like, oh shoot, nobody has any money here, we're not going to get anything, then typically I will decline taking that matter. I don't want to have to go to the time of, filing a complaint, serving all these people, and sort of walking down this whole process, if at the end of the day there's nothing there. And that presumes that, there's no collateral worth getting, no real estate. It's a different situation, I think, if you have, assets there that have value.
Yeah, I agree. For the brief stint I did as a creditor's lawyer here for 2 years, I was always baffled by creditors asking for us to do things on contingency when they knew there was no money there. Well, just file it anyway. Just do it. I just want a judgment. And they couldn't understand that if you don't think you're going to get any money, I'm not going to get any money, and I don't work for free. So obviously that's a concern. You should look, and if they still want to sue, they can pay me hourly, frankly. That was always my worldview on that.
Yeah.
But I'm not in that world anymore, so I don't do any contingency fee arrangements with debtors, as you might imagine.
And I think we've hit on most of the things that, we would put in our engagement letter. Obviously clearly define the scope of your representation, regardless of whether you're on the debtor side or the creditor side. I always, put the payment terms in there, any disclosures that you have to make about conflicts of interest. We also usually include language in there, just indicating how we're going to return documents at the end of the case, who's going to be keeping the originals, that type of thing. Also, if it's a situation where we're acting as maybe special counsel or local counsel, or we're representing several, different parties, I usually put in there a sentence or two just saying who I can take my direction from, because that makes it a lot easier down the road if you have one person who's going to be calling shots and communicating with you. And usually, there is one sort of ringleader, if you will, in your client group. And if not, I'd rather know that everybody wants to be involved in the process up front than find that out further down the road.
Which that also brings up another issue that just came up for me too. I have a lot of issues. Another case of mine, the funding source was not the debtor. And that does happen a lot, obviously. The debtor borrows money or somebody else comes in and pays for them. And there has to be a clear definition of what that contribution is, meaning this person that funded the client's bankruptcy then decided it also controlled the bankruptcy, and I had to refer him back to the documents that were previously signed that clearly indicated the debtor is still the client and controls regardless of the funding source. So it can create problems when you get money from other people funding for debtors, so that's also something to be mindful of, is to make sure you've got that signed and everybody's clear that you represent that person and not the one that funded it.
I think moving on, the next sort of step in the process, if you will, is when you get an inkling that something might be wrong, that your credit relationship might be heading south, and there are lots of, different signs that might clue you in that you have a problem. I think one that we've been seeing a lot lately is the obsolete product or service. The Reader's Digest bankruptcy, I think, was a great example of that. Everybody's shifting to a more electronic, form of media as opposed to going out and buying, paper publications. And I think we're also seeing it too as we see the shift more to online retail sales. I think that has been a huge, change in the retail environment, and so I think we're going to see a lot more retailers file in addition to those that already have. So those are a couple of things to be looking for there. I think another point that we often see that will signal that something is amiss is if we have a particular, customer who always paid on time and now all of a sudden is dragging its feet and paying late. If we have somebody who's supposed to be giving our client financial reporting and, for a while had been really good about doing that, but then all of a sudden stops, it always makes me wonder, okay, well, what's in there that they don't want us to see? It can't be good, which prompts usually more questions, and then all of a sudden you discover that, lo and behold, there is an issue lurking there. I think Charity hit on a couple of other points, which would be like, changes in management or changes in key personnel. Usually that's a sign that there may be some strife and that things aren't going as they should be.
Moving locations usually is a pretty good indication when the debtor has to downsize, sell off equipment. And I'm talking about one I just filed for that everybody should have seen it come in, but the bank still seemed like they were blindsided. When the principal of the debtor moves a substantial amount of money out of your bank, it's probably coming. So there's lots of signs, obviously, for a troubled company. I look at them also when the Chapter 11 debtor's dealing with other vendors. We have the same case is Chapter 11 over in the Western District, and our main vendor is showing signs to me of being in sincere financial trouble right now. And so I've had to have a heart-to-heart with my Chapter 11 debtor about getting a backup plan in place. So it doesn't stop even on the just lender side of things. As a business debtor, they've got to be mindful of whether or not they're going to be able to collect, especially when they're in Chapter 11 and everybody's watching them, whether they can collect.
I think lots of times there's a domino effect. If you have a business Chapter
True.
11 debtor, then all of a sudden, its particular suppliers and vendors are hurting because they haven't been paid, and then that in turn sort of causes them to have financial difficulties, and they sort of flounder, and then, they have to let people go and shut the doors, and then you get the whole sort of trickle-down effect,
That's true.
if you will.
Absolutely true. That's what's happening here, I think.
So, and I think another indicator that we often look at too is whether or not we have a particular customer who's, changing their purchasing habits. Are they buying a whole bunch of stuff all at once where they never used to? Are they, essentially stockpiling and getting ready to prepare to file? Or are they buying virtually nothing? And is that because that they're, getting ready to just shut their doors, throw the keys on the table, and walk away? So just a whole... Yours never walk away.
No, this is where I have the best story that I ever tell. So when I represented actually the principal of a debtor, somebody else had the debtor, down in Atlanta, Georgia, this was like in 2007. I don't know that Kentucky experienced the same gas shortage we did in Georgia, but literally you could not get gas for days there. People would just leave their cars on the highway because there was no gas station with gas. So this debtor, who was in trouble, decided to spend the weekend filling up tanker trucks, driving around, and just got tons and tons of gas from Manchester Oil, all the big oil companies. And they didn't have anywhere to store it because of these tanker trucks had to be emptied to go back and keep tapping these oil, the gas tanks. So the guy, the owner of the debtor, allegedly, purchased some military-grade canvas bladders, like huge 40,000-gallon bladders, and buried the gas in his yard on his farm, allegedly. And that was luckily Manchester Oil was the lead creditor on that. And they realized by Sunday, when it was already too late, that they had just been taken for a ride. They knew what was about to happen, and they were in court. I mean, the debtor, of course, filed Sunday night. they were in court Monday morning and had it converted to a 7 and had the principal pretty much getting a criminal attorney at that point. So, but Manchester Oil was watching. They said, what's going on? This is crazy. Why'd they tap this so many times? And they were in there and took control of the case.
I bet they had a lot of environmental issues too, if they
You
were
think?
burying bladders.
You think? I did not represent the principal for very long. Because he needed criminal counsel at that point. So.
Yeah. Oh, yeah. I think the next step in the process too is your due diligence. Obviously, if you recognize that something's going wrong, you want to start planning. So at least for the lender or creditor perspective, I think that due diligence is important for two big reasons. One, it helps you determine whether or not you actually want to stay in the relationship or if you want to get out. And if you do want to stay in, it gives you an idea of, potential problems in your documents that might need to be fixed. And it also is an opportunity to sort of uncover things that may be problematic for you further down the road. I think these days some of the juiciest stuff that you tend to find is in, communications back and forth in emails and text messages. Just because people are so much less formal in those forms of communication than they typically are in a letter. So I think the first step is you want to determine what the document or documents are that make up your relationship with your customer. It could be, just one big supply agreement. It may be a note and mortgage and several other additional documents. You want to take a look at everything. If there's a document that's incorporated by reference that you don't have, I always like to get a copy because sometimes the boilerplate language in there can be helpful to you or it can be harmful to you. You really don't want to leave any stone unturned. And we've included in your materials basically a checklist of various provisions within the documents that we each look for. One of the big things that I look for are notice provisions because I want to make sure that if I'm sending out a notice of default that I give notice in the way that's required by the documents and that I give it to everybody who is required to receive it. I'm a big fan of giving notice to, multiple people at various locations. If I think that they may have some, interest, I see no downside necessarily in serving them with notice. So I'd much rather, be in that position. And oftentimes, even if my documents have, the obligors waiving notice, I will still go ahead and give them notice because I want to be in a position to say, hey, you knew this was coming. This was not a surprise to you. So.
And from my side of things, as soon as I see a forbearance agreement come from the bank, I say, don't sign that. Let's see what we can do. Maybe we should file an 11 before you sign that. So I obviously don't like forbearance agreements or truing up documents. I do look for the buzzwords of all the waivers and the releases and all the things that Emily is very good at making sure her client gets. Frankly, there's not much you can do in your debtor's counsel except live with it. I mean, they're either going to sign it because they desperately believe that they can turn this whole thing around and pay off $1 million in 6 months, or they're going to file, generally speaking. But there isn't a whole lot on debtor's counsel side you can do with a forbearance agreement, other than, make sure you're not going to Texas, for venue, stuff like that. You look for those kinds of things. You look to make sure there's going to be a notice issued. You want to make sure your client's got 10 days to cure. Those types of things are what you put into the documents when they're being shored up again, and basically the lender is going to get your client to waive all their rights ever.
We typically always look to make sure too that there's a jury waiver in the document. Typically speaking, I think that jury trials, at least from my perspective or from a creditor perspective, tend to be a little bit more expensive and a little bit more uncertain. And usually, not all the time, but usually there's one party who may be more sympathetic than the other. So we always like to make sure that jury...
And it's not your client.
Sometimes it is. It depends. So we usually want to make sure that that's in the document. And, 9 times out of 10, if it's a matter that goes to litigation and there's a jury waiver, they'll still make the jury demand. But then you just go ahead and, make the motion to strike it. You kind of have a sense that that is coming and that just sort of, in the pipeline. But again, it's always helpful if you know up front whether or not you have that, because that can color your strategy, in your case going forward. So,
and I could care less because I'm going to bankruptcy court and I don't have a jury anyway, so. whatever, you can have your jury waiver, no big deal.
I think another thing too that is often, helpful, we always look in our documents, or at least I do, for any, type of cross-collateralization provision. I think sometimes when a loan, finally comes to us and it's in trouble, it's not uncommon for the loan to be several years old. So I think sometimes folks forget, what exactly the terms are that they have in their documents. And I had a case several years ago that had a cross-collateralization clause in it, and I had 3 different loans. And fortunately for me, that the collateral, which was actually a life insurance policy, had been pledged for a particular loan, but it also had the cross-collateralization clause in it. So when that policy was liquidated, it essentially paid that first loan, and then it paid a portion of the second loan that was also underwater. So, and my client was like, oh, you're right, we do have that clause in there. I hadn't thought about that. So again, part of your job is to just kind of go through and make sure that all your ducks are in order.
There was a wonderful period of time where I saw a lot of the smaller banks that did not have cross-collateralization and cross-default clauses. And one in particular blew my mind because they pretty much, there was excess in an asset that was pledged as collateral on one loan, but because they didn't have the language, they didn't get the excess. They went to the bankruptcy estate and went to the creditors. So sometimes they're not there. I'm glad when they're not. So as a debtor's lawyer, I always look to make sure they're actually there. I look at the timing of the loan documents. I look at the timing of when assets may have been pledged again, whether they're actually done correctly, whether the mortgage was done correctly, that kind of stuff. And so, sometimes you get lucky.
Yeah, make sure that your UCC financing statements, if you had any, were continued.
That's right. Sometimes those are terminated accidentally. Those are nice.
Well, and sometimes notice isn't given, to senior secured
That's
interest.
true.
So,
Right.
There's all sorts of things to kind of think about when you're doing your due diligence.
Yeah.
A couple of other, points we put in here too, and you see these more with real estate loans. You want to look and see if there's a clause for assignment of rents and profits. That's always a nice one to have. Usually there's a license back to the debtor that essentially permits it to go ahead and collect the rents and profits so long as it's not in default. But once there's a default, as the lender, if you have that language in your document, you can go ahead and send the letter and say, start sending your rent to me. So that's, you want to be aware of that. Another one, receivership provision. Sometimes there'll be language in there where the borrower actually consents to the appointment of a receiver upon default. Other times it'll just be language saying that it's one of the several, remedies that you might have if there's a default. So you want to check that and see how strong your language is in that document as well. And again, part of the reason for doing this is to make sure if there's anything that has been left out or omitted and you're trying to do a forbearance or some type of other structured agreement, is that you can kind of clean it up on the back end.
Yeah, and from my side, obviously, I always look at the receivership language to see if I can challenge it. I mean, if it says they may apply for the appointment of a receiver, we've had a lot of luck with that in Jefferson County. Usually you can go ahead and say, well, it says they may apply. That doesn't mean they get it, Judge. You got to decide whether or not they're entitled to it under the statute, and that's carried the day for us many times. So, but when it does say you automatically get it in the documents, we lose every time. So.
Yeah, so you want to make sure what you
Right.
got. Another thing, personal guarantees. Kentucky has a very unique and wonky personal guarantee statute, so you just want to, read through that and make sure that your guarantee complies. So
Yeah.
that can often be a nice argument in the summary judgment setting, is whether or not you have an enforceable guarantee and if all the boxes were checked off.
That's right. I always look at the guarantees. Is it enforceable? Is it written on the document that it's supposed to be, or is it attached to it? Does it refer to the loan? Sometimes I'll look at it and go, oh man, they didn't put the loan number on it. They didn't put the maximum amount indebtedness, all kinds of stuff. And then you flip the page and it's all there. You expect to see it kind of in the heading, but it's not there. But generally speaking, banks seem to do that right. It's usually going to be your smaller commercial like vendors and stuff that you'll find that have done it incorrectly.
Mm-hmm. Yeah, and sometimes you can get some mileage out of it.
Right.
So, it's another argument to
Bargaining
throw back.
chip.
You bet,
Right.
Absolutely. You always want to check and see, as the attorney, if there's an attorney fee provision or prevailing party provision, at least from my perspective. And I think, as we mentioned earlier, again, just go back and look at any communications that have gone back and forth. Lots of times the juiciest stuff is in the text messages or in the emails. So you'd rather be aware of those up front than all of a sudden when you're at the summary judgment stage and somebody throws up this huge roadblock for you. Oh, well, there was this email and it said yada, yada, yada. So you just want to be careful about that.
Or when you're in court and somebody posts your debtor standing in front of a $500,000 boat that they didn't put on their list of assets, that's always fun. And it was from Facebook or somewhere else. So yeah, you want to know what's out there. I do now more regularly search my client social media accounts and otherwise to try to figure out what they're doing.
Yeah, and that kind of leads us to the next point, which is evaluate your collateral. What do you have? You know, this is important to the lender because obviously the lender is always looking to get more collateral or, you know, collateral that may not have always been pledged. And I think from Charity's perspective, they are looking to see if there's anything else that they might be able to offer up in terms of getting a deal done. That's what we like to think.
Right, sure.
So at least for your real property collateral, you want to make sure that the property description is correct. Every once in a while, there will be an issue with that, and you want to, you know, be aware of that so you can get cleaned up. You want to make sure that there's insurance on the property. If there's not, you may want to consider going ahead and force placing it. It may be an expense that you will be entitled to recover under the loan documents. You want to make sure that you're also listed as the lost payee because lots of times the borrower will forget to do that. So don't be afraid to ask for something from the insurance company showing that you are actually listed as the lost payee. With respect to personal property collateral, again, we've talked about looking at the UCC statements, making sure that it was properly filed and that the description was correct, making sure that it hasn't lapsed, that notice was given to any, you know, prior holder if it's a PMSI sort of situation. You also want to confirm the location of your collateral if you can. Sometimes, you know, I had an instance once where, you know, our collateral was like 100 tractor trailers that were, you know, all over the country and some of them in Mexico, so it was rather hard to determine what we had and where. But, you know, if you have inventory, you might want to go out to the warehouse and just kind of eyeball it and make sure that, you know, what they say they have, they do. And again, I think, you know, just like with real property, for that personal property collateral, you want to make sure that it's insured.
Yeah, whenever I meet with a client that's, you know, a business debtor, prior to the meeting, I always run a UCC search because a lot of times they don't pay attention to what they've pledged or secured or what's out there and they think they have, but they haven't, those kinds of things. And I'm frequently surprised by what I find. A lot of times I don't find UCCs that are properly recorded. I find some that have terminated or lapsed because they didn't renew them. So for me, I'm more or less looking to see whether or not it was done correctly. For an interest in a deposit account, you know, that's not enforceable unless you've done the pledge agreement, the control agreement with the debtor and the bank. So I look at those types of things. Even though a creditor may think they have an asset, if they haven't done it correctly, they probably don't.
And I'm sure you pay attention to the timing too. Is it something that might be capable of avoidance?
Right. Timing is definitely something we always look at. When was it pledged? And whether it was going to be, you know, especially if a bankruptcy is imminent. So.
Yeah, and I think also you want to go ahead and be evaluating, obviously, the debtor's financial position. You want to be looking at all their financial statements and reporting that they're supposed to be giving you, and you kind of want to look for patterns. You know, is this a particular, you know, customer who always has trouble in the spring, but then things get really busy and business tends to pick up in the fall? Or is this something where they're just sort of limping along and have been for a really long period of time, such that it's more of a chronic problem than a seasonal problem? Because I think it's obviously easier to get somebody over the hump if it's a seasonal issue, or if it's a one-time, you know, deal where something has happened that has caused them to have a hiccup.
Yeah, so. And I think one thing I've noticed with business debtors is that they generally stop paying attention to their finances when they become worse than expected. And so when they can't answer my questions about things like that, like when's your good time, when's your bad time, who are your customers, how many receivables do you have, what's your average type of customer, it's probably a good sign they're in trouble. Because if the answers are, I don't know, I think so-and-so, well, yeah, we're busy in June, and I say, you know, but
what does busy mean?
Well, what does busy mean? Who are your customers? And they can't really answer those questions. And yes, this happens to me more often than I care to say right now. But if they can't answer those questions, they really don't know what's going on with their business, and that's probably a sign that they're in significant trouble.
I think another thing to look for too is have they been liquidating assets or trying to convert assets, because that's usually a sign that something is also.
See, the whole converting assets thing, I got to wear two hats now. I was named a Chapter 7 panel trustee over in Indiana in September. And so now I get mad when debtors do stuff with their assets. But
Which is new for you, isn't it,
it
Jerry?
is, because now I'm chasing down things. And I guess I always joke that I was appointed to the panel to take me off the streets, because I see the tricks of the trade and I know the conversion and what's done. And I certainly talk to my debtors about what to do for pre-bankruptcy planning and that kind of thing. So it's sort of tricky for
Be
me.
a fine line.
Yeah, it is. And so I've gotten less aggressive, I would say, with pre-bankruptcy planning now that I have to go back through everybody else's stuff and police debtors somewhat. So that is something to look for, though, obviously. I have been successful in some pre-bankruptcy planning over the years, I will say. And usually when debtors start converting liquid assets, obviously, to annuities, life insurance, retirement, I feel like I'm giving away all my tricks. I'm trying to think what else we've
Pay down a mortgage.
paid down a mortgage. One case that I talked to Emily about recently that I was not involved in, I just looked it up because somebody related to the case asked me to represent them and I declined. But that case, the debtor, when they were in trouble, prepaid their kids' private school tuition, paid down on or took out a line of credit, I guess. Did a lot of crazy things, pre-bankruptcy planning. Said it was on advice of counsel. I don't believe it really was, and neither did the court. The court actually agreed that it was not on advice of counsel, and that wasn't a defense to the things that he had done. But
Denied the discharge. Yeah.
Denied the discharge, yes.
So there are instances where there's smoke, there's fire.
Where they go too far, I would say that. And I think I put that in what we have here. There are times when the courts have found the pre-bankruptcy planning to be perfectly acceptable.
Yeah, we've got examples in your materials.
yeah.
I think we've included the case sites as well.
Yeah, so there are, you kind of have to look at it from the perspective of what's the harm that was done when the conversion happened, if they were converting it to exempt assets, and can it be gotten back fairly easily? In situations where people take out, lines of credit and then spend the money, basically they leverage their home and then spend the money putting it into a retirement fund or paying off something else, they're going to have problems. Generally, if they've taken an IRA and they put it into an exempt pension, the court doesn't have a real problem with that from what we've seen. Paying on your mortgage is usually not a problem just because you're going to increase your homestead exemption. And I mean, your equity for your homestead exemption, the court's fine with that. Those kinds of things where I think the court kind of views it as no harm, no foul, when you're not really going too far with it and the creditor was going to get paid anyway. It was a secured lender. They were first in the pecking order, that kind of thing.
Yeah, and then I think the next, let's see here, the next part of the process, if you will, is trying to reach some type of an agreement outside of court before you have to go ahead and file the lawsuit or before Charity's client files for bankruptcy. So there are all sorts of, different tools that you can use to try to go ahead and avoid that. We've included information about pre-negotiation agreements, forbearance agreements, loan modifications. And so I think for Charity and I, we're both, pretty big fans on the pre-negotiation agreements just because it kind of gives everybody the ground rules for what is going to occur and how the communications are going to take place. I think that, the creditor always appreciates when the debtor is open about what's going on. I think sometimes that lack of information is the, scariest part of the whole process. So, I think most of my clients are usually willing to listen to why this particular borrower or this particular debtor is in this financial situation and see if there's, something that can be done to kind of resolve that. So again, the pre-negotiation agreements are helpful because all communications are essentially settlement discussions, so it's kept confidential. Usually, nothing is binding unless signed in writing, which is, consistent with most of the terms in your loan documents. So I only have good things to say about P&As.
Yeah, I agree. I think the biggest thing about the pre-negotiation agreements from the debtor's perspective is with the climate of lender liability claims and issues that come about with just a email back and forth exchange between a loan officer and a debtor, this is the one way for us to get the bank to the table with some assurances that they can talk openly and frankly without it being binding or used against them later or showing up in some kind of, counterclaim saying you promised me X, Y, Z and you didn't give it to me. So I think it's really good on both sides because it helps the open flow of communication.
It does, but that presumes that you have time, and it's not an emergency filing.
Right.
That's, coming down the pike. But when you're able to get them, I think it's helpful. Typically in the ones that we do, either party is free to walk away at any time, giving notice to the other. So it's not like you're stuck for 6 months waiting for something to happen. Oh, yeah, it's coming, we're gonna get you that stuff, and it never comes, you can walk away.
Right.
So that's one of the tools that we like to use in the process. I think the next type of solution that we like to look at are forbearance agreements. They tend to be, at least from our perspective, typically short. They're usually less than a year. It usually gives the debtor some time to go ahead and see if they might be able to shop the credit around and perhaps refinance it or pay it down through an additional infusion of collateral. We typically ask for waivers of any claims that the borrowers and the guarantors may have against the creditor, and charity usually pushes back on that.
Right.
But I think that's one of those topics to discuss. If there's really nothing there, I think it shows a sign of good faith to the bank or to your creditor. I think another thing that we often consider and go back and forth on is whether or not we're going to request a fee to be paid for doing any type of forbearance document. Sometimes we'll request a pay down up front, and if we're able to reach a solution, we'll go ahead and waive it at the end of the deal. But usually, we like some token of good faith.
Yeah, and for the forbearance agreements on my side, I'm not totally against them, as some may think. I think there are times when they're useful, particularly if this is a client. I mean, I've had it happen in the last year where the client truly was waiting for a sale to occur and be paid, and then he was going to be able to buy out this note. And I knew from this client's history that that was true. And so the short forbearance agreement with the waiver was no big deal. We did it. He sold it, paid it off. Everything was fine. And I think he did pay a fee for the forbearance, and I was fine with that as well because he certainly could afford it. But more often than not, the debtor cannot afford it. And I look long and hard at a forbearance agreement that's really buying them time to go chase windmills and really isn't going to actually produce any real results. So then, at least as their counsel, I would advise against it. Whether they still sign it or not, whole nother ball game. But I don't usually think it's well served for anybody to just stall out the inevitable, which is that the bank's going to ultimately take over the collateral. So.
Yeah, and I think another tool that we often talk about for longer term solutions, obviously, is a loan modification or restructuring. And at least with those, there's all sorts of room for creativity. You're doing new documents, so you can play with the interest rate. You can play with the maturity. You may require an additional guarantor that you can look to in the event of a default. There may be additional collateral other than a guarantor that you can grab and have pledged to you. So there's all sorts of areas that you can look at if you want to keep this credit and think that it might be viable going forward.
Yeah, and generally the loan modifications, also similar situation. They're only going to work from the debtor's perspective if there's an investor, new money, some change in control, something that's going to actually change the debtor's trajectory. And then a loan modification makes sense. Otherwise, I don't want them pledging more collateral and re-upping with the bank. So. Yeah.
If the bankruptcy is inevitable, it doesn't make any sense for them to be incurring the fees and costs of paying you.
That's right.
To negotiate these types of agreements.
That's right.
I think the next item we have in the list is consensual foreclosures. Those can be very popular, especially where you don't have any liens against the property other than maybe tax liens. That's usually a nice solution. It saves you from having to file the complaint and incur all the legal fees. It's also quicker because you don't have to wait to get a sale date.
Yeah, and from the debtor's perspective, the biggest reason I love deeds in lieu of foreclosure, even if I can't get them released on the deficiency, which is obviously the first, is I say, sure, we'll give you a deed in lieu. They've got no money. Let them go. Don't sue them so they don't have to file bankruptcy. When the bank tells me no, because they more often than not do, the only thing I care about at that point is getting the property out of the debtor's name before I file bankruptcy. Because one of the worst things we've seen happen over the years is that the bank will foreclose, have the right to take title to the property and choose not to because it's in, an abandoned part of Chicago, one of my cases right now, and it's incurring fines and all kinds of fees daily, and they don't want it, frankly. So it just sits in the debtor's name, and I've done them no good by filing a Chapter 7. Now they have all these post-petition fees or expenses from the property that are non-dischargeable. So for me, it's a win, even if I don't get a release of the deficiency claim, to just get the property out of their name.
Yeah, and I think another tool too, oftentimes if there are additional, debts on the property or liens on the property, we'll do some type of agreed judgment where, nobody contests basically the sale, and that allows us to go ahead and essentially clean up the title to it. And if we're going to take it back, at least we're taking it back without all the liens attached to it.
Right.
So that's another, popular tool and popular out for you as well. Those do require some coordination, which is where, again, your whole, pre-negotiation agreement comes in handy.
Right.
Lets you know if that's a possibility. It's something that you can talk about early on. So just another thing to keep in mind.
Yeah, and it's best if it's in rem, only against the property and not against the debtor.
Yeah. From your perspective,
Right.
Yes, absolutely. I think moving forward, obviously, if none of those solutions work, you're looking at litigation. You're looking at filing a complaint. Where you have real property, you need to go ahead and file in the county where the property is located. If you have property that's located in more than one county, you can file in any of those counties. So just something to be aware of. We've included in your materials a little checklist of the various allegations that you're going to want to include in your complaint. You're going to want to allege the execution of all of your documents, the validity and priority of your liens. You're going to want to make sure that you state whether or not the property is divisible. You're also going to want to go ahead and request interest, fees, costs. If you've advanced any costs or anticipate advancing more costs, you want to claim those as well. If you have a receivership provision in your documents and you're considering appointing a receiver, we'll often include a count in the complaint for the appointment of a receiver and then follow up with a motion requesting the appointment of a receiver. So again, there's a little checklist that we've included in your material. I think sometimes when you're moving fast, it's nice to have a document to go back and just double check yourself with. So we've tried to do that here.
And I defend them, so I don't have much to add to that. I hope you missed some of those things when you filed them.
Right after the filing of the complaint, you also want to go ahead and file your lis pendens notice. Over the years, I've noticed that different counties, at least throughout Kentucky, have different requirements for what they want in their lis pendens notices that are often found in the local rules. For example, there are some counties where they want the case caption to include the names of all of the parties, not your just et al. Abbreviation. So you want to go ahead and make sure that you at least check the local rules so you have an idea if anything special there is going to be required. I usually file the lis pendens notice immediately after I file the complaint, and then I come back to the office and basically have somebody date the title, just because I want to make sure that no liens or additional items have come on the property since the last time I had that title run. So just another sort of practice pointer there as well. If you don't file your lis pendens notice, then the interests of any subsequent lien holders will not be cut off at the sale. So you really want to make sure that you get that on as soon as possible, because you don't want any nasty little surprises when you're getting ready to sell the property with the sheriff and the master commissioner's office.
Yeah, and as far as the debtor's concerned, we hope you get a surprise and can't sell it, so.
With respect to the answer and counterclaim, you've kind of already hit on it a little bit. You want to be looking at whether or not there are any, potential lender liability claims there. You're also probably looking at whether or not you want to include a demand for a jury trial.
Yeah, frequently you go ahead and include that, but the one thing that I do in defending a foreclosure action is I have the client go back through to their emails, their correspondence, their phone records, anything that they have, and I also make them sit down and write me a timeline of, when the loan started, when the forbearance agreement was done, how the collateral was pledged, the conversations that were happening. Because I'm frankly looking to see where something was done wrong. And the only way I can find out where something was done wrong is to go through the entire transaction from start to finish. Like one that started in 2013, I have them go back and start at 2013 and tell me everything that happened through the 5th forbearance agreement that we're on. To tell the story. And believe it or not, sometimes they forward me smoking gun emails that shock me that came from, the vice president of the bank saying it's no problem. Of course you have another year on this. And then they take their stuff the next day. So it happens. So that's what I do as far as defending a debtor. Now, more often than not, they come back and say, I don't have any emails. I just know so-and-so said it to me when I saw her at the grocery store, or things like that. In which case, no, I'm not going to file a counterclaim. Yes, I will aggressively defend, but I'm not going to assert frivolous claims on behalf of a debtor that absolutely have nowhere to go. I may assert some different defenses for them that is usually based on the guarantee, whether the mortgage was done correctly, whether it was recorded correctly, whether everybody's been included in the lawsuit, those types of things. But it's a rare occurrence that they actually come up with a document in their possession that is a smoking gun. But it does happen.
Well, and I guess the rare occurrence on the creditor side is every once in a while you'll have a borrower who decides they're not going to answer the complaint. And if they don't answer within 20 days, they're in default, and you can go ahead and move for that default judgment. I think lots of times where we tend to see that is if you truly have a borrower who feels like they're underwater, there's not necessarily much they can do. They don't have any assets really to offer up. They may decide it's cheaper to just, let the lender take the property back and, have them go through the foreclosure process, especially if they haven't guaranteed it, or if they have guaranteed it, they really don't have anything to back up that guarantee. So for us, that's usually a rare occurrence, but it does happen. We had one case several years back where we actually had a borrower and some guarantors who didn't answer the complaint. And so we moved for a default judgment, got the default judgment, and we were getting ready to go ahead and list the property for sale. And lo and behold, in the court's file, there is an answer to a complaint that hadn't been served on anybody, handwritten on legal paper. So again, it's just one of those sort of wonky things that happens that you have to deal with and that you don't necessarily expect.
Yeah, and I would say sometimes that the debtor doesn't file an answer because their bankruptcy lawyer said, don't bother, I'm going to file for you by the end of the month. I mean, that's usually the way it goes for me. I say, there's no point in paying me to defend this. We're going to file bankruptcy anyway. So.
Yeah, but sometimes they won't. So we've had
True.
that too. So it just sort of depends. Anything can happen. Don't take anything, I guess, for granted. I think you want to know what you can realistically expect, but sometimes you do get lucky. We hit on it earlier, talking about a little bit about unenforceable guarantees. That's another, affirmative defense or claim that Charity usually makes back if she has it. We've also included in your materials the Equal Credit Opportunity Act violations. Typically, I think where we tend to see those is if there's a claim that the lender essentially required somebody to put their spouse up as a guarantor. You can volunteer your spouse to guarantee, but the lender basically cannot mandate that it be your spouse who goes ahead and also issues the guarantee.
Well, and that's the case when, for instance, the husband has been the only wage earner for 40 years, and he was creditworthy based on his own credit, and the bank made the decision just based on his finances to lend the money. They cannot then come back later and
Correct.
say, go ahead and have your spouse sign too anyway, though, because they didn't make the credit determination based on her or him.
Right. And if his credit alone wasn't sufficient, they can't say, okay, now you have to give us your spouse. They can say,
Then they
okay,
can run
we want to
hers. Right.
Right. And you can offer the spouse, but you don't have to give the spouse, although typically that's usually
Yeah,
who
but
it
I
is
have
unless
seen it
you
as,
have other principals in your company.
right. I have seen it as an after-the-fact request, though, by an insurance company actually once when it happened. So it does happen. You can't, if you've decided their credit based on one person, you cannot then later go tell the other one they have to sign too.
We've also included just a little checklist in your materials for your judgment and order of sale, and the various terms that you want to include there as well. I do note that if you have to cancel a sale or postpone a sale, the Master Commissioner's Office will usually charge you a substantial fee for that. So just something to keep in mind. We had a situation several years ago where the borrower was begging for more time and was convinced that they were going to be able to refi and, keep the property. And so part of the deal that we had made was, okay, if you want us to cancel this sale, then you're going to have to pay the sale cancellation fees because otherwise we're marching forward. So that usually tells you fairly quickly if they're serious or if they're just trying to stall and buy more time. And in our instance, they actually were able to refi the property, and they did pay for the cancellation fees, which were several $1,000s at that point. So just something to kind of, keep in your mind and sort of be aware of. Typically, once the sale is conducted, the master commissioner will go ahead and file a report of sale. You have 10 days within which to object. I don't know that I've ever seen anybody object to a sale. I'm sure it happens. It's not something I think that routinely happens, but again, just something, again, to keep in mind on that as well.
I object to the master commissioner reports a lot, but I don't know that I've objected to a sale.
Yeah. On the personal property front, we've also talked quite a bit, I think, already about enforcing your security agreements, doing all your UCC searches. I think lots of different, remedies for you in order to try to, resolve that. I think one is self-help, which you don't usually see. And I think the reason that you don't typically see that is because in order to go ahead and properly execute that, you can't disturb the peace. And so there's case law out there that basically says if the borrower tells you to stop, then after that point you're disturbing the peace. So it's not necessarily like Dog the Bounty Hunter. Not necessarily work that way. So that's one possibility. Another possibility is to go ahead and basically dispose of the collateral by sale. If you're going to do that, it can be a public sale, it can be a private sale. You just want to make sure that all of the other lien holders are given advance notice of it.
Well, and that you're following the statutory guidelines on giving notice of the sale, and that you're making the correct disposition of the collateral. So, as far as the borrower is concerned, the prejudgment issues that come up, obviously, is we're always looking to whether or not their bank accounts can be wiped based on deposit account agreements, those types of things. And so kind of going back to the sign of the troubled borrower, usually when I see it on the horizon, I've got them moving their money pretty quickly somewhere else. So when your borrowers start moving money quickly, that's probably what's going on. And yes, I usually have them move it out of state. It doesn't stay here. So that's a tool for borrowers. That's something I tell them usually is move your stuff, get it to where nobody can get to it because it's about to happen. You're not going to make that payment. You're going to be in default. And so they have some self-help remedies that they can do.
Yeah, I think in your materials too, just because we're running out of time, we've also tried to include stuff on writs of possession, garnishments, and again, I think with all of those attachment, you just want to go ahead and pull the applicable statute and make sure that you're checking off all the boxes for what's required for those various remedies.
I will say something on that. The one of those issues came up recently too. There's the charging order remedy where you can ask the court for a charging order against the debtor's interest in the business that they own. And there's a lot of misunderstanding about what that actually means. And because it happened to a client of mine, I had to actually research it recently. And the charging order effectively entitles the creditor to any dividends or any payments that the debtor was going to receive from the company. It doesn't actually give you the right to go foreclose the interest that you are charging against. You just have the right to the extent, it's basically a garnishment. To the extent they're going to get a dividend or some kind of distribution from the company, then the creditor would be entitled to that pursuant to a charging order.
Yeah, I do know other states will permit you, though, to foreclose. Kentucky does not, but there are.
You can in Kentucky, but it's incredibly difficult, so. Yeah.
Be careful.
And then my favorite topic, are we going on to bankruptcy?
We can. We will flip through.
I mean, bankruptcy, obviously, when I meet with clients, we're usually talking about whether they need to shut down the business and file personal bankruptcies, because by and large, I don't file bankruptcies, Chapter 7s for companies, because it's pointless. I mean, if it's just liquidating and there's nothing for anyone to get except for the secured creditor to get their stuff back, it's really just a waste of time and money. because then the individual's gonna have to file anyway.
Well, and you get all the avoidance actions too in the Chapter 7. You have, as you know, the trustee. So you want to be careful
Right,
about that
which is
as
another
well.
reason I don't file for businesses,
businesses,
so
yeah.
people don't get sued. So a lot of times I don't file for the Chapter 7 business, I do file for the individuals. But it's, initially when they come to meet with you when they're in trouble, from my perspective, they're usually unsure of what they want. They come in and say, I want a Chapter 11, I want to save my company. And then you say, well, what is there to save? Well, I don't know, I lost my contract, I've been evicted from my space, and my house is being foreclosed, and I can't put any more money into it, and I haven't paid myself in a year. And then you have to explain to them, they don't need a Chapter 11, they need a 7, and probably an individual 7. So there's different types of bankruptcies. I have never filed a 13, so I won't pretend to ever be an expert or even speak on that. I've never done anything in a Chapter 13, so. There are different types. As a creditor, you need to pay attention, enter your appearance, file your proofs of claim, those types of things.
Yeah, make sure you get all your calendars and everything deadlines so you don't miss something. Those bar dates can sneak up on you quickly. And if it's a big mass bankruptcy, like, one of the cold cases, Patriot, Arch,
Right.
Alpha, you want to really make sure that you read that bar date notice carefully and closely. Oftentimes you have to send, the proof of claim by a certain receipt deadline to the
Right.
claims agent. You may have to serve, debtors counsel with copies too. Sometimes they try to add additional loopholes that you sort of have to jump through.
And as debtors counsel, I like to always include a provision that requires you to file a proof of claim regardless of whether I've scheduled you or not, or otherwise you can't participate. So always look for that too. Make sure you don't have to file a claim. If you're scheduled and you think you're comfortable, then fine, but it's usually better practice to go ahead and file the claim. And I think we're done. So it's been I think this is 8 years for me total, 4 years of doing it every other year. It's been a great 8 years, Mindy, but I say goodbye. Yeah, thank you. Thank you.
Thank you.